Welcome back to the Emily Show Monday edition, quicker than a live stream, quick bits. Well, that's what we're going with now. That's just how it is. We have a lot to talk about today, from a fact check on the Real Housewives of Orange County reunion trailer, as this is all coming up, because I saw it twice and I was like, wait a second, Shannon Beador. That's not what the court documents say. So we need to talk about that in the facelift lawsuit. Kouri Richins was back in court last week. I have some quick updates on what happened. We have a wild judge case, and the texting judge that I covered was one thing, but is this judge in the YouTube chat of his own streams, of his own courtrooms? He's also being sued for something else. We have to talk about it. And at the end of the episode today, I'm going to quickly cover what is happening in court with the Laken Riley trial. I know that you've probably seen that the defendant in that case opted for a bench trial. I'm going to go over just a summary of what that means and the process that'll be taking. It is not a case I'm covering closely and not a case I'm covering streaming day to day, but I'm going to give an overview of what's going on in case you've also opted out of the streaming coverage of that case. But I will remind you before I get into that story at the end. So with that, let's get into it. Emily, even the intro is not quick anymore. I know. It's just the Monday show. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. First, we have to talk about Shannon Beador. You saw in the trailer for Real Housewives of Orange County, the part 3 of the reunion, if you are a Real Housewives watcher, that she gets into it with Jesus Jugs. And if you do not watch Housewives, just give me a moment, I swear I'll explain. But Alexis, aka Jesus Jugs, is dating John Janssen. John Janssen is Shannon Beador's ex. Emily, it sounds like you're talking about people in junior high. I mentioned that we're talking Real Housewives. Indulge me for a moment. So John Janssen and Shannon break up. Shannon gets a DUI thereafter. And shortly before the expiration or the deadline for the statute of limitations, John Janssen sues Shannon Beador over a facelift. Yes, you heard me correctly. If you want to deep dive into this, I did cover it on an episode of the Vile Files, and I will link that down below. If you want to hear more Emily pop culture, because there have been so many filings in the criminal cases that I'm covering, we haven't gotten into enough reality pop culture law. Not nearly enough. So John Janssen sues Shannon for over $75,000. He says that that was a loan for a facelift. She said it was a gift, though on the show, there are times where it seems that she's indicating that he offered to loan her the money because interest rates are higher, and taking out a loan for the facelift before the season aired or started to film or whatever was not what she intended. And then half of this season, she was talking about all the money she spent buying him shoes and belts and what have you. And last week I covered the engagement ring and who gets what. And in that case, there was a promise to cover dental surgery. And at the breakup of the relationship and the breakup of the engagement, the party that had promised to pay for the dental surgery ended up being required to pay for the dental surgery. But it seems that John Janssen is maintaining that this was never I'll pay for that for you. It was always well, if you don't have the money up front, interest rates are high, I'll just float it as a loan and then you can pay me back. And Shannon has vacillated between that's not the case and but that's not equal because I paid for all this other stuff. Well, of course, the entire plot line around Alexis has been her new man, defending her man, and boom, I got your man, and the rest of it. So in the trailer and in the teaser for the next episode of the finale is Alexis and Shannon yelling at each other. And Alexis says to Shannon, I'm not going to apologize for defending my man. Aren't we, ladies? Aren't we all like well into our 40s and beyond? Either way, I'm not going to apologize for defending my man. He was still going to sue you. To which Shannon replies, and I ended up winning. Asshole. That was the direct quote. And I ended up winning, asshole. So, fact check. I went to the lawsuit and yeah, they're not done by any means. Nobody's won. I mean, nobody's lost, I suppose, either. But no, nobody's won. The last thing that was filed in the facelift lawsuit were all of their case management statements. And their case management statements were filed November 7th, 2024. And in the case management statements, they all indicated that they are amenable to a settlement conference. And everyone requested a jury trial if this goes to trial. If this goes to trial, it won't be till like 2026, but if this goes to trial. But they all required a settlement conference, not ADR, not mediation, not arbitration, settlement conference. So maybe they are in the process of working out a settlement, but that's not the same as, and I ended up winning, asshole. There was no winning here. It is not over. It is not done. So for all of you that were like, we need a legal fact check, there is the legal fact check. That case is not done. It is still pending. There is no settlement at this time per the most recent court filings. They have asked for a settlement conference. That might happen. Settlements are normally a compromise where everyone is slightly disappointed with the compromise. So we'll see if this ends up settling and everybody walks away. You tell me in the comments if a settlement is a win or if it's just done. I want to know what you think. Moving on to a defendant that was really pissed her lawyer wouldn't smuggle Crest white strips to her into custody. We need to talk about Kouri Richins. Emily, are you being hyperbolic? Nope. No, I'm not. That comes from the Walk the Dog letter. If you are new to the Kouri Richins case out of Utah, there's a whole playlist on the Emily D. Baker YouTube channel. I will give a quick summary. Kouri Richins is accused of murdering her husband with a fentanyl-laced drink. She is also accused of attempting to murder him on Valentine's Day about 2 weeks before he ultimately passed from a 5 times lethal dose of fentanyl. She has been in custody since her arrest. She was arrested almost a year after the crime. She wrote a children's book about grief after the passing and or murder of her husband and was on a bit of a local media book tour at the time of her arrest in 2023. She's been in custody since then. She is on her second set of attorneys. She's also the one that we learned early on in documents was Googling things like luxury prisons for rich people. Since the preliminary hearing, we've learned quite a lot more, and her digital devices are quite a trove for the prosecution. Lead prosecutor in this case, Mr. Bloodworth, no, I'm not joking, has some of the snappiest writing in motions work that I've ever seen. And man, the shade doesn't stop in this case. But again, I break all that down on the Emily D. Baker. And if you have the Lawnerd app, you would know that because you would have seen that I was streaming the last court hearing, or at least sharing with you the parts of the court hearing we have access to, because this judge, though made for TV, is very much not a fan of the case in his courtroom being readily accessible to the media. So there are quite a lot of restrictions. So if you don't want to miss a minute in that case, it's going to be going to trial in May 2025. LawnerdApp.com. Get you your free Lawnerd app. Don't miss a minute on this one. It is interesting. There's also a ton of financial stuff wrapped up in this. Emily, you would take a whole Quick Bits episode to summarize this case. Yes, I would. But she was back in court with a renewed motion for bail that was denied, which is what I think is going to happen to Diddy in his renewed motion for bail as well. But she also had a motion to sever, which the defense won in part. The motion to sever was to take out some of the counts she was charged with, because she is charged with murder and attempted murder. She is charged with insurance fraud with relation to the murder and attempted murder, and a life insurance policy that she took out on January 29th, 2022. And then the attempted murder is alleged from February 14th, 2022. Whoever would have wondered how a life insurance policy is taken out so soon in time to somebody's death by overdose. But there were also mortgage fraud counts from more than a year prior relating to forged documents, Kouri Richins using her husband's business bank account to say it was her business bank account to portend that she had more liquid assets than she did when she was taking out these incredibly high interest loans to continue to build her real estate empire in the Park City, Utah area. She was incredibly in debt and the financial situation was imploding running up to the murder. She already had a paramour, as he is referred to in court documents, that she was texting that their life together was going to get better, and did at one point say, "Don't worry, things will get simpler. Just wait till Friday," which is when her husband ended up dying. But all that aside, we also have the prenuptial agreement in this case that indicates that if she got divorced, that she would take essentially what she came in with and what she had created in her business. He would keep his business, but that if he died during the marriage, then there was a lot more assets to be gotten. And the financial considerations are a part of the motive as argued by the state in this case, but the mortgage fraud counts are not going to be considered by the jury. Some of the debt and some of the financial motive will come in at trial, but not those counts particularly. Also in Utah, for non-capital cases, they only seat 8 jurors, not 12. The defense made a motion to seat 12 jurors. That was denied. The defense and prosecution stipulated that there should be an expanded veneer, meaning a larger pool of jurors. Instead of a change of venue, they asked to bring in jurors from multiple counties instead of just Summit County, and that will happen in this case. And they asked to have jury selection in person. In Summit County, they are allowing for mostly remote jury instruction, like literally via Zoom, and that will not be happening in this case. The jurors will need to come to the courthouse, and that will all get started in May 2025. What I appreciate about the judge in this case is that he is incredibly thoughtful, but he is also very decisive in his rulings. He mostly rules from the bench and is prepared to do so. A little bit different than a judge on the bench potentially chatting with YouTube chat while their courtroom is streaming. Yeah, we need to talk about it. So there are multiple headlines with regard to Detroit Judge Kenneth King. And the first headline that came to my attention from Judge King was the fact that he is being sued by a teen whom he held like a fake contempt proceeding for. We're going to talk about that. But also that his use of the YouTube chat is under scrutiny. This is coming to us from the Detroit Free Press because this judge streams his courtroom on YouTube, as a number of jurisdictions do. But what has caught the attention is that it seems that the judge appears to be texting. And at one point, there was a designated moderator. We'll get back to that later. The Detroit Free Press's story indicates that during a child abuse trial, the chat's designated moderator, which name indicates that they are connected to the courtroom, said that she would gladly catch a case protecting these babies, which it's a sentiment I think most of us can understand, but it is a public comment that those connected to a courtroom cannot make in that way, and judges cannot comment on cases they are presiding over, which causes concern. The article then goes on to say that when commenters in the YouTube chat began getting confused, asking questions about the witnesses, the judge appeared to start typing. Quote, "Tony is the defendant," wrote the commenter, CTRM, courtroom, 234, 36th District Court, as one of the girls fielded questions from a lawyer, girls, victims in this case. Then another note from the court handle popped up. There is a Tony Jr. too. So this is seemingly a judge in the YouTube chat answering chat questions while on the bench presiding over an incredibly sensitive trial. But wait, there's more. It said that kind of interaction between the court account and King's scores of online followers is not unusual. A Free Press investigation found evidence that suggests the embattled judge routinely engages with commenters on the social media platform, including in the middle of court proceedings. YouTube chat. Chat. What? Your Honor, you are either on the YouTubes or in the court. I don't think ethically you can do both. It said at least once he appeared to miss a lawyer's objection while monitoring the online chat. And in the case of the twin girls that we had just been talking about, the court's account expressed an opinion in the chat about the defendant and the case 5 days before determining if there was enough evidence to send it to trial. So the proceeding must have been a preliminary hearing. The judge is the one in charge of determining if the standard of probable cause has been met. Judges aren't ethically to express their opinions on cases in that way. They rule from the bench and that's it. Does that sound incredibly restrictive? Yes, it is an incredibly restrictive job. But you can't comment on cases in chat. We saw this with Texting Judge commenting on cases on Facebook. What? It goes on to say the Free Press reviewed video that shows King typing at roughly the same time comments appear in chat. The commenter uses first-person pronouns, including my orders. Rachel McCrae, who until recently moderated King's chat, said King was the one posting under the CTRM 23436 district handle. And in 2022, King told a news outlet he posts at times in the chat, although he said not during proceedings. 2 judicial officials with some oversight powers of the court told the Free Press a judge commenting in a live chat during a hearing was inappropriate. You think? And a national judicial ethics expert said a judge expressing an opinion on a case is problematic. That's to put it mildly. Even reading comments during a hearing could be improper if posts reveal details about the case not presented in court yet. Yes, it's why courtrooms shouldn't have chat turned on. If you want to have chat turned on, stream video games, not court. Because judges can't really even express easily opinions on other cases either. It goes on to say King did not return calls seeking comment. His lawyer did not immediately answer questions on Friday about his use of YouTube and chat. And the criticism about the judge performing, quote unquote, for an online audience is one of the criticisms in the lawsuit we are going to talk about next. The article goes on to say that the Free Press found King goes beyond simply streaming. In addition to apparent commenting, he had McCrae, a private person who lives in Georgia, as a volunteer chat moderator. She had the power to remove messages and prevent others from making comments. Chief District Judge William McConaughey revoked McCrae's moderator privileges on Monday, calling them a security risk. He said the decision to give her that control is part of a separate investigation into King's conduct. The chief judge said he'd already spoken with King about his use of the live stream and chat in the past, and this usage played a role in his initial investigation into King's conduct with the sleepy teen girl, which we are going to talk about next because that has sparked a civil lawsuit. Earlier this month, McConaughey removed King from his docket and ordered training, saying King's approach to the girl's behavior was antithetical to the court's mission. Jurists chatting with observers while on the record is not and has never been appropriate, McConaughey told the Free Press in an emailed statement. Yeah, you can't do it in live court. You're definitely not doing it on YouTube. Under no circumstances should any member of the general public be allowed to censor and or remove access for other citizens, and we consider this to be a breach of the court's security. We are investigating and will address further in a manner fitting to the seriousness of the situation. Tom Boyd, Michigan State's court administrator, said he was surprised and troubled to hear of a judge commenting during court proceeding. He's a former district judge himself. I would not do that, and I personally find it incredibly inappropriate. It goes on to say whether any of the Free Press findings on King's YouTube use violate court rules or canons of judicial conduct is a question for the state's Judicial Tenure Commission, Boyd said. Commenting about his chat, Judge King in 2022 spoke with Deadline Detroit about his followers and interacting with him online. It said, quote, I noticed there were a number of people that were chatting on my YouTube feed, and they were from all over the country and all over the world, King told the publication. And so I started chatting back with them between cases, never during a case or about cases. The thing is, court feeds shouldn't have any YouTube chat on, I would think. The amount of problems it could bring to a court is substantial. And most of the cases I cover, the courts do not have chat turned on in any way. And most news outlets don't have chat turned on in any way, unless they are news outlets like a WFLA that streams. It said, but video of King from 2022 obtained by the Free Press shows even then he appeared to be responding to comments during the proceeding. During one hearing in February 2022, King appears to miss a lawyer's objection because he's engaging in the YouTube chat. One commenter told King not to laugh at something said in the hearing. King is wearing a mask commonly adorned during the pandemic. The court chat account typed in the comment, I think I'm going to wear a mask forever. Another commenter post, Wacky Wednesday, and the court responded with an LOL. At that point, a lawyer objects. King had to ask both lawyers to repeat themselves before he could make a ruling. That article from the Detroit Free Press is from August of 2024. And when all of this was going down, there was an investigation into this judge that seems to still be ongoing. However, he was removed from a criminal courtroom and put into a traffic courtroom, which is a much different type of assignment. But that's not all. He was also sued in August, and I guess we're going to call this the Sleepy Teen incident, at least for now. But it is a field trip to court that did not go the way anyone would have expected. And to find out what happened there, we're going to go directly to the lawsuit filed in the Eastern District of Michigan on August 21st, 2024. And the reason this case is coming up, I recently just saw it covered by Law 360, but the judge is making a motion to dismiss based on judicial immunity. I am not an expert in all things judicial ethics, have not been a judge, just know a lot of judges. But generally, judicial immunity extends to official duties. So if you are a judge and you happen to get in a car accident, you can still be sued over the car accident. But if you are a judge and you make a ruling and someone says it's violating of their rights, you generally can't be sued for that. So as we look at this, keep that in mind, because the judge has made a motion to dismiss subsequently, saying that he is protected because of judicial immunity. But this is what is alleged by the minor plaintiff by and through a guardian. The minor in this case is using the initials ELG. That is what we are going with. And the suit says, ELG fell asleep in class. She was the involuntary attendee of a guest lecture that her vocational trainer arranged to occur. I think the reason they're using that language is because of the lawsuit, but her school. The venue of the lecture was room 234 of the 36th District Court. Defendant Judge King was the guest lecturer. Court was not in session. During the lecture, defendant King felt personally disrespected when the teenager expressed her opinion of the lecture by nodding off during the presentation. Look, people fall asleep in class. People fall asleep in lectures. It happens. I mean, if anything, have the bailiff go and nudge the student, be like, hey, just, you good? Maybe just check. Streaming the lecture live from the court's YouTube platform, defendant Judge King decided to enact his own version of the reality show Scared Straight by ridiculing ELG in front of her peers and the defendant's online followers. He made ELG an unwitting actor in his improv version of the Star Chamber. He berated the minor on a live platform, ordered her jailed, caused her to be handcuffed, demanded that she take off her clothes and change into jail garb, presumably back in lockup, not in the courtroom on YouTube, imprisoned her for hours, and then conducted a fake trial with her classmates and possibly his internet followers as her jurors and his audience. They say defendant King's extrajudicial actions violated the minor's constitutional rights, subjecting him and the other defendants to liability, as stated in the balance of the complaint. Any defense of immunity will fail. So they attacked the immunity argument head on in this complaint. It goes on to say that on August 13th, 2024, 15-year-old plaintiff was participating in a vocational program run by a local nonprofit organization. The nonprofit employed teenagers to plant foliage throughout the city of Detroit and organized programs to teach youth how to succeed in the workplace. The nonprofit organized the field trip to the court on the 13th, where students who wanted to be attorneys could learn about a career in law. They go on to say that this minor was not really particularly interested in law and aspired or aspires to be a cardiothoracic surgeon. Permission for ELG's participation in the trip was not sought from her mother, otherwise she would have stayed home or attempted in advance to arrange work with a crew that was not scheduled to travel to court. It goes on to say that court was briefly called and the young people were required to observe a homicide proceeding that was presided over by the judge. The court went into recess after the proceeding and the defendant's judge role changed from judge to teacher. They say Judge King left the bench and asked the students who were attending whether any of them wanted to be a judge. One young man raised his hand. The defendant disrobed and donned the child with his judicial apparel and seated him at the bench before proceeding with a monologue regarding his practice of law. Although court was no longer in session, the defendant broadcast his lecture publicly using the court's YouTube platform, permitting his followers and fan base to both observe and comment. An otherwise shy, polite, and courteous Miss ELG, who was not interested in the practice of law and who had had a rough night's sleep, unintentionally expressed her disinterest in the proceedings by nodding off after being exposed to a court hearing that forced her to relive a traumatic event, causing her to shut down. The thing is, people fall asleep in court sometimes. People fall asleep in movies. People fall asleep in class. It happens. It goes on to say, neither she nor her mother consented to her attendance at a hearing involving violence or the use of her image and identity on a public platform during an educational seminar, which is a very good point. Defendant King publicly berated and humiliated ELG for nodding off, falsely casting her as a juvenile delinquent because, as he later said, he was disrespected. I was wondering how they knew that. Apparently, he said it. It goes on to say that the plaintiff quietly apologized. The judge temporarily moved on, except despite her efforts to be attentive, she could not stop her mind from seeking a safe place and nodding back off. The judge confronted her again for sleeping in class, instructing her that perhaps she needed to go to the restroom and get a drink of water. The judge told the plaintiff to go relieve herself because of what he had in store for her. It's apparent that he developed a plan for the amusement of his followers and fan base to cast ELG unwittingly in what he later described as his own episode of Scared Straight. It said that the plaintiff was greeted by defendant John Doe, court officer. Others are being sued in this lawsuit as well, as she returned to the gallery to sit beside her classmates before the judge convened court. Defendant court officer derided the plaintiff and accused her of disrespecting the judge. Then court officer directed her to the side of the bench and restricted her movement by ordering her to stand still as a real defendant was escorted out of a detention cell. The court officer next directed ELG into the detention cell and locked her inside while the judge brought court to session and called his first case. Approximately 10 minutes later, defendant Jane Rowe, court officer, opened the detention cell and handcuffed the plaintiff and directed her to another cell where she was told to strip her clothing and put on a jail jumpsuit. Then she removed her hoodie, but told the court officer she would not take off the rest of her clothing. Fair. Plaintiff was permitted to put the jumpsuit over her clothing before being handcuffed and transported back into the holding cell, where she was held captive, it says, for hours before being recuffed and brought into the courtroom after the close of the day's court proceedings where a fake trial was convened. So the court ran his whole calendar and then had her come back out of the holding cell. Despite the entire episode being broadcast on YouTube, upon information and belief, there was no court record of the sham proceedings. But the sham proceeding continued. The judge caused a random private attorney to pose as counsel for ELG. On live internet, quote-unquote television, the judge coerced the minor to disclose her name and other personal information, such as her age and the name of her high school, to the followers of his show. It's also bad. Also, juvenile court proceedings are sealed to protect the identities of minors. There wouldn't be a juvenile court proceeding like this ever. There are very limited circumstances where juveniles are tried as adults, and this is very clearly not one of them. It goes on to say that the judge threatened to send the plaintiff to juvie with vulgar stories of beatings and feces at the county's juvenile detention center, falsely casting her as a dishonest, disrespectful delinquent and simultaneously publicly disparaging the conditions of the county-operated facility where judges with appropriate jurisdiction and proper findings of fact have been determined with due process of law are required to send juvenile offenders, then making a mockery of the justice guaranteed by the Due Process Clause of the Constitution while panning the camera to focus on the juvenile audience for the benefit of his internet fans, the judge asked the peers to serve as a fake jury of public opinion and decide whether to let her go home to her mother and grandmother or to serve time in the juvenile jail that he had moments before denigrated as unfit. It goes on to say, of course, the judge was not going to send her to jail as there was no actual case or controversy, and because he admitted to the press that the foregoing was simply his version of quote unquote scared straight because he was going to teach this teen a lesson for disrespecting him. That's what he told the news. Then the lawsuit says, rather than using the press as an opportunity to extend an apology for what many have labeled as extreme and outrageous conduct on the judge's part, you let me know down below what you think. The judge doubled down, telling reporters that plaintiff had a bad attitude, was disrespectful, and required his mentorship, while simultaneously offering a watered-down acknowledgement that he lacked jurisdiction to hold her in contempt, knowing that the conduct that disturbed him occurred during a lecture where he was not serving as a judge but a teacher, in a venue that he had transformed from a courtroom to a classroom, telling the public that he probably did not have the authority to jail her, which means he wasn't acting in his official capacity as a judge, which means judicial immunity is likely not going to apply here. It says that as a result of his anger, the defendant immaturely decided to teach plaintiff a lesson in front of her peers and his internet audience. The lawsuit goes on to talk about the constitutional violations that they're alleging, the lack, they believe, of judicial immunity because this was not a judge acting in his official capacity, but acting out of personal motivation, and cites a substantial amount of case law on that point because they knew that's the argument they were going to face, and brings the other causes of action in the lawsuit, including intentional infliction of emotional distress. The judge goes on and responds to this with a motion to dismiss. The response to the motion to dismiss again argues that there is no judicial immunity here and that this is clearly the judge acting outside of his official duties. Let me know if you want me to follow this one. I'm very curious to see what the court is going to do. I'm curious to see what the Judicial Ethics Committee is going to do. I am horrified for this teen. That is not what reaching out to the community in a positive way looks like. And putting someone in lockup for the entirety of the court proceedings because they fell asleep without inquiring any further about what was going on. It's just preposterous. And in most cases, if somebody in the audience was repeatedly falling asleep, the judge would have the bailiff kick them out of the courtroom. Like, that's generally the result. But jurors have fallen asleep and courts take breaks. Court is already intimidating. But for bailiffs to order a teen to strip and put on jail clothes in the courtroom lockup, like the lockup connected to the courtroom, is wild to me. I am regularly stunned by some of the cases and stories that we come across, but this combination of YouTube and chat and abuse of discretion is absolutely wild to me. And I feel for this teen and am proud of her family for seeking a lawyer, which isn't always easy, and for taking on a member of the bench in a lawsuit that is going to take time, energy, and resources. But I don't often offer opinions on cases. I'm not mad at this one at all. I'm not mad at this at all. Good for them. This is absolutely ridiculous behavior. And I wonder if we will see this judge removed from the bench. Maybe we will, maybe we won't. But this never should have happened to this teen in his courtroom. Thank you to today's sponsor, Lume. My skin is starting to just be as dry as can be. And one of the things I love about my Lume deodorant is it never makes my skin feel dry. And as we are getting into boot season, do not tell me that you have never taken your boots off and gone, whoa, boy. When they say it works from your pits to your feet and everything in between, it's true. It's developed by an OBGYN, so it is well balanced for your skin and to crush odor. Plus, when you add in the body wash that starts beating odor in the shower, you've got an impenetrable duo for up to 72 hours of odor control. And if you're not sure what you want to try, Lume's starter pack is perfect for new customers. It comes with a solid stick deodorant, cream tube deodorant, and 2 free products of your choice. And you can try out the mini body wash to see if you love it. Plus, you get free shipping. And as an offer for our listeners, new customers get 15% off all Lume products at lumedeodorant.com using code EDBQB. And if you combine that 15% off with the discount on the starter pack, it's up to 40% off of the starter pack at lumedeodorant.com using code EDBQB. That's LUMEDEODORANT.com using code EDBQB. And if they ask, let them know that I sent you. So smell fresher and stay drier with our sponsor, Lume Deodorant, and boost your confidence from head to toe. Thanks to our sponsor, Lume. Let's get back to today's episode. And I am going to shift and talk about the Laken Riley murder trial going on in Georgia. It is a difficult topic. It is a sad case. And as I do with difficult topics, I am not going to get into all of the details that have been learned in court. That's easy to find. It is my goal to give an overview so you understand what's going on legally and then a bit factually as this case has gotten started on Friday. No, it is not a case I am streaming. No, it's not a case I will be streaming. If there is a lot of interest, maybe I will consider going over opening statements, closing arguments. This is not a case that's going to a jury, and that's what I want to talk about first. You may recognize the name Laken Riley. This case did get politicized. That's not what we're talking about today. We are talking about the facts of this case. Laken Riley was a 22-year-old nursing student at the University of Georgia, and she was murdered when she had gone out for a jog and was dragged off the jogging path and attacked by the defendant, Jose Ibarra. He has opted for a court trial, not a jury trial, probably because the facts in this case are horrific and involve his fingerprints and his DNA and him being on video. He is charged with more than 10 counts, including 3 counts of felony murder, malice murder, kidnapping with bodily injury, aggravated assault with intent of rape, aggravated battery, hindering a 911 call, tampering with evidence, and a peeping Tom charge. We'll talk about that in a moment. This trial started late last week in Georgia, again, as a bench trial. The judge is the finder of fact in this case. So the case might move along with less objections than you would see in front of the jury because the judge is going to ultimately be deciding. Do I think the judge will deliberate long with themselves? Probably not. Do I think this trial will take very much time at all? Probably not. If convicted, the defendant faces life without the possibility of parole. What came in quick succession as this trial started on Friday were some of the facts of the case, including the fact that she was found more than 65 feet from the traditional running trail where she regularly ran. With any kidnapping, there has to be movement away from the area that you are. I haven't looked at the case law in Georgia. 65 feet to an area that's more secluded and wooded is generally going to be enough in most jurisdictions for a kidnapping to stand. They also found the defendant's thumbprint on Laken Riley's phone in generally the area you would press to hang up a call, and evidence came in that Laken had called 911, but the call was hung up. There's also video of a man who the prosecutors say is the defendant. I'm sure more evidence about that will come in, disposing of bloody gloves and a jacket that was later recovered and tested and shown to have Riley's DNA on it. There's also a video hours before the murder of the defendant looking through the windows of a female student's apartment in the UGA village and trying to open her door. That student subsequently called 911. There was also evidence of the injuries to the victim, Laken Riley, but also photos of the injuries to defendant showing how hard Riley fought back. And there was testimony that came in about the defendant's DNA being under her fingernails. Again, I don't think this case will take long. I don't think the evidence will take long. I don't think the judge will take long. But if you are watching this case as it's streaming and are wondering where the jury is, defendants can opt out of a jury trial. And I'm not surprised, given everything that came in on Friday, that they did. But again, the evidence in this case is overwhelming and strong. So I don't think this will take long. The only thing I'm surprised by is if you're going to opt for a bench trial, why not just plea to the sheet and be sentenced. I don't know the choice that was made there or why, but it's interesting if you're taking a bench trial, unless there are particular legal arguments that the defense attorneys want to make. Arguments like, is it really enough distance for kidnapping? Can you really show the aggravated assault with intent? Can you show that intent? And really making some of those legal arguments to the judge based on what we saw on Friday. I don't know how far they will get with those arguments, but that might be why the defense wanted to make some of those arguments to a judge. Those types of legal arguments might actually carry more weight with a judge than with a jury, because with the evidence in this case, trying to make nuanced legal arguments to a jury is going to fall very flat into the realm of, but we've heard from the coroner, so I don't want to hear any more about anything. Where with a judge, getting into the more nuance of the finer points of the law might have a little bit more weight. But from what I've seen in court on Friday and what I've seen of these charges, I don't know if that's going to get very far, but we will see what the judge decides to do probably next week. Hopefully that gave an overview of why there is no jury in that case. If you are choosing to watch it as it is streaming across the interwebs, I have chosen not. And with that, law nerds, sorry to end on a heavier case. This is a heavy case, but I hope it helped explain at least that a bench trial is an option, though it is an option very rarely exercised, especially in homicide cases. With that, thank you for being here. And don't forget, go grab the Law Nerd app so I can keep you in the loop with all of the cases I'm covering this week. We have much to talk about. There are filings in the Karen Reed case we haven't gone over. There are filings in the Kohberger prosecution we haven't talked about because they're brand new. We're waiting on rulings in Karen Reed. We've got an update on Tuesday in the TikTok psychic case. And on Wednesday, we're going to be talking about Alec Murdaugh's accomplice getting a new trial on appeal. And of course, there's more Diddy, because at this point, there's always more Diddy. And with that, thank you for being here. Thank you for being a Law Nerd, and I will see you in the next one. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.